Hello, good afternoon, good morning, ladies and gentlemen, and welcome to today's Masterclass on data protection, EU data protection and the General Data Protection Regulation. The program is recorded, and our speakers today are myself, Karin Retzer. I'm a partner in Morrison Foerster Brussels office, and I'm doing this with my colleague Alex van der Rolk. He's a partner in Berlin and London. And before we start off with the master class, just some housekeeping matters. For those of you who do this part for CLE credit, make sure that you register for CLE credit on the login page already, and then you will get regular prompts. You have to respond to those, and then at the end you should complete and submit a short online evaluation form, and then you should get your certificate within about 2 weeks, and this masterclass qualifies for 1.5 hours of CLE credit. And if you have any questions for Alex and me, you can do that on the site. You just click on Ask Questions, and then you type up your question, and I hope we will have time at the end of the webinar to address them. If not, then we will get back to you by email later. Then if you have any technical problems or issues, then you can click on the site as well, help, and then you can also call the technical support service at 01415-247-7600. Then let's get started, and we start off with slide 1. Alex.
Yes, thank you, Karen, and good afternoon and good morning to all of you. The topic of the day is the EU Privacy and General Data Protection Regulation, or acronyms to GDPR. We'll be referring to that. And maybe to get started on, why privacy? Why care about privacy? And I think to many of you that may be a somewhat of a ubiquitous question. I think many companies by now know that privacy is something that individuals, consumers, and employees are concerned about. And individuals have also become much more savvy about privacy rights. I mean, in Europe alone, we currently have a Data Protection Directive, which has been into effect since 1995. But it's not just Europe. There's many laws around the world, and we're seeing an expansion of knowledge and privacy laws to begin with, I think, everywhere. So it almost goes without saying that privacy is something that companies can use to differentiate themselves, to set themselves aside as a branding effect of how they deal with privacy and data protection. And at the flip side of that is, risks of reputational damage. We see, especially in the context of, for instance, data breaches, that the downside of not handling personal information well can be very big. And I think in the context of the GDPR, the topic of enforcement is one that has kept many people up and quite likely will still keep many people up at night. Which is why we pulled it forward to the very first slide of our presentation, just to make sure that everybody is aware of that and put it up there. So we see, and I think that this should not come as new to many people, probably, but we see a substantial increase in finding power by DPAs, where currently the European data protection authorities each have their finding power or enforcement powers, rather, under national law, and they differ quite extensively from country to country. Some have no finding powers at all. Some have more substantial finding powers. But under the GDPR, that's something that will be harmonized, and with a maximum finding power of 20 million euro and 4% of global annual turnover or revenue. Now, the 20 million and 4%, that's the highest category. I think the majority of violations under the GDPR are one category below that, but that's still 10 million euro and 2% of global annual revenue. And that is the group's revenue. There's some indication as to how that should be calculated, but for all purposes and means, companies should take into account that that's the global group's turnover or revenue. So that can be a potential very high fine. And then, in addition to that, we see that the rights and remedies for individuals are also, expanded or fortified at the very least. They can lodge complaints with data protection authorities. They have the ability to obtain judicial remedies and compensation. So I think in that context and against this backdrop, we're going to see an increase of almost seriousness, I would almost call it, with regards to powers that individuals and authorities have. And that's going to have an impact, and that's going to be of importance to companies that are involved in this area and to whom this pertains. And with that, I hand it over to you, Karen, to discuss the scope of application of the GDPR.
Yeah, thank you. And one of the major changes under the regulation is the much broader geographic scope. So the European data protection requirements will be more relevant for a much broader scope of companies worldwide. And when you look at slide 3, it's basically there are two categories of companies that are covered. And with companies, I mean not just data controllers, so organizations that are responsible and that are in charge of the data processing activities, but also data processors, service providers who use the information on behalf of customers. And it's really the first time for many countries in Europe where these service providers or data processors are directly captured. And there's quite a list of new requirements for these service providers. There's been a lot of debate during the legislative process, and initially the idea was service providers would be covered in entirety and all the obligations would apply. This didn't really make a lot of sense. And the ultimate compromise was that service providers would be subject to some obligations, and we'll talk about that in more detail. But it's new that they are directly liable. And liable are both controllers processes that are established in Europe, and that can be a subsidiary, that can be a small representative office, that can be even some salespersons with some permanence in country. So it's not required that you have some legal entity there, but it's some local presence for some substantial period of time. And then even where you're established outside of Europe, you may still be covered by the regulation because you're offering goods or services to Europeans, or you're monitoring the behavior of Europeans. So it's really quite broad. And then when you look at slide 5, what means offering of goods and services? It's not necessarily that you offer goods or services for a fee and you charge for that, but it can be website content that is provided for free, some brochure sites, and that's quite important, I think, because you may have sites hosted out of the States that have information, free of charge information, and these sites may now be within the geographic scope of the regulation. So it's not limited to services products for a fee. What is important is whether you target Europeans, because I think at some stage that the European regulators realized that it can't be every site. And they kind of used a consumer law concept that a site in the U.S. targets Europeans by either having local language translations available, of accommodating different currencies, so where you have a possibility to pay for some products in pound or in Europe, or where you have delivery locations in Europe, or where you have a choice to have you can select your region, and then European countries are listed. So that all may amount to targeting, and then you may be subject to the regulations. So it's very much a consumer law approach, and it's not what you had previously. Varies the equipment, varies the organization, but it's very who are aiming at. That's even stronger when you look at the second possibility where non-European organizations can be subject to the regulation. That's on slide 6, where you monitor behavior of Europeans to the extent that behavior takes place in Europe. This kind of carve out behavior taking place in Europe, I kind of wondered what this means, and I think the only explanation is that it probably meant to exclude Europeans traveling outside of Europe. I'm not sure that exception makes an awful lot of sense, but I think there it is. So if you monitor or profile Europeans in Europeans, I think when you think about it, every more sophisticated website does that. You use tracking cookies, you use geolocation on mobile phones for location-based services. You may screen activities. So it's really quite broad, this monitoring concept. Or for example, where you run analytics on European employees out of headquarters, that activity would be covered. Or for demographic studies. I think given the advance of monitoring or profiling technology, I think very many applications will be subject to this applicable law rule. And then when you're covered by European law but are not established in Europe, then you're still subject to the full range of EU obligations, and that's on slide 7. But in addition, you have to appoint a local representative in Europe. And you actually had that requirement already under the directive. But under the directive, it was largely ignored. I'm not aware of a single case it was enforced. And the data protection authorities didn't really like that because they want to have somebody locally that is liable, responsible, they can talk to in local language. And now there is a penalty if you don't appoint a local representative, and that may be 10 million or up to 2% of worldwide annual turnover. And you have to document the appointment in writing. So you have to have that on file. And there's a small exception of that if the processing of data of Europeans is not large scale and is not sensitive data and there's no danger for privacy, then you don't have to appoint that local representative. But it's probably not really helpful in practice. So for many non-European organizations subject to the regulation, you now have to appoint this representative, and it's quite broad. And then Alex is going to explain the increased scope, the increased substantial scope on slide 8.
Yeah, thanks, Karen. And just one comment or note on the fines. So the 4% or 20 million, or the lower category 10 million or 2%, that's the higher of the two. Whichever of the two is higher, that's what the DPAs can impose. So just to clarify that. On the concept of personal data, the definition itself has largely remained the same. So it's still any information relating to an identified or identifiable natural person, which is also the case under the directive. That's not new. But the definition has been expanded to take into account guidance that we saw, being published over the last years, notably guidance in the form of opinions by the Article 29 Working Party. We already knew that those opinions considered personal information or personal data to include information that singles out individuals. So it's not required that you have a first or a last name or other direct identifiers. If you're able to single out a person, to know over a period of time that the person is the same as he or she was yesterday, for instance, in the context of a website, take an IP address. If that's a static IP address, and you can identify that person over time as the same person, that qualifies as personal data. So even though you don't know who the person is, or it may actually take quite some effort to find out who the person is, especially in the context of IP addresses, typically it's the internet service provider that has the additional information, not the website owner. But still, those identifiers are considered personal data, and that's been codified now under the GDPR, where an explicit reference is now made to identifiers, including online identifiers. And I think that's important to note because currently there's still DPAs that do not necessarily consider, for instance, IP address to be personal data or other identifiers, and especially in the online context, as I already alluded to. I think this is an important note. But the GDPR doesn't leave any doubt about that as far as I'm concerned. I think this is pretty much clear that those kinds of identifiers and the concept of singling out is now captured under the definition of personal data. So that broadens up the scope. I mean, to the extent it wasn't already broadened up through guidelines and working party opinions, but that broadens up the scope. And I think through that, we're going to see that, many companies, process personal data. I mean, currently they already do. There's only very few companies, I think, that do not process personal data. But with the expansion of the definition, I think that's going to be even more so. So that's something to be on the lookout and be mindful of.
And that's particularly relevant for the UK and Ireland and some of the more lenient countries, because in these countries you could often argue that it was indirectly personal and was subject perhaps to the full range of obligations, but that's no longer the case because the regulation applies a rather strict standard now across Europe.
Yep.
And then when you turn... Yeah.
Karin, you want to take it further for consent?
Yeah. On slide 10, there was a lot of debate during the legislative process on what form consent should take. Consent used to allow collection, allow use, allow sharing of data. And the European Parliament for a very long time really asked for explicit opt-in consent. And there was a lot of back and forth between the Council, the Member States, and the Parliament. And in the end, the compromise that was found was that you have to have a clear affirmative action, but not necessarily explicit consent. And to my mind, that's very similar to what you have currently for cookies. So you have something between a explicit tick box and some right to object somewhere hidden. I think it probably needs to take some form of affirmative action or some indication of wishes. So mere silence, just a pre-tick box, or some assumption of consent that's not sufficient. But then for most sets of data, you don't need explicit opt-in consent. That said, you still need explicit opt-in consent for certain types of data, namely sensitive data, when we're talking about medical information, when we talk about union membership, information on sex life, religious beliefs, and so on, then you still need explicit consent, so that remains unchanged. But what's now different under the regulation is that you also need explicit consent when you want to base your transfers outside of Europe to a non-European country and that is not considered adequate. When you want to use consent for these transfers, then you have to have explicit consent as well. That's probably quite tricky for example, for websites that want to use consumer consent as a basis for these transfers. So that now needs to be explicit, but not the remainder. There's also an expectation that consent needs to be more granular, and you may need to get re-consent after a certain period of time. So I think now is definitely the time you need to review your consent mechanisms and see whether what you currently have on your websites, in your forms, in your processes, whether that's sufficient to comply with the new more increased standard for consent under the regulation. Alex, do you want to talk about consent for children data?
Yep. Moving on to slide number 10. So one of the things that it differs quite a lot from country from member state to member state is the definition of when someone is a minor. And I think by and large, most countries set that age at the age of 14. But there's other countries that in Europe that set that age to 13 or 16 or even higher, up to 18. So the GDPR harmonizes that to some extent by making the default age 16. But at the same time, it says that it's up to member states that they can lower the age to 13. So we're hopeful, and it's a good thing that an attempt to harmonization has been made. But especially those countries where the age is currently lower than 16, our expectation is that they will use the ability on a national level to again lower the age to as low as 13. When an individual qualifies as a minor, as a child, it means that for the processing of the child's personal data, consent needs to be given by a parent or guardian. And that's always a tricky aspect, because the question is, how do you go out and verify that the parent or guardian has in fact provided consent? And to what extent do you have an obligation to verify whether it's not the child, in fact, that resembles or passes off on the parent's consent? The GDPR says that the controller must make reasonable efforts, and that's a very nice open norm. It doesn't qualify or codify how much efforts need to be made. Reasonable can go a lot of ways. And it should be taken into account, I think, the proportionality, the technology used, the data that's going to be used pertaining to the child, that will ultimately drive the standard for what qualifies as being reasonable. And the more sensitive the data will be, or the more intrusive the technology will be, the likelihood that there's going to be additional efforts required by the controller increases. And there's a number of examples, I think, where controllers, which controllers can use, which companies can use to verify age. There's the option of age gates, where you ask a person's age before he or she enters personal data, for instance, on a website. And then on the basis of that, you would distinguish whether or not the service is accessible to that person. Other options are double opt-in, where you send a verification link to the parent's email address that needs to be clicked. Voice recognition. We've also seen credit card payments for a very low amount that need to be made. All those kinds of things can be used ultimately to verify the parent's consent. But there's no silver bullet. There's no one-size-fits-all. It will depend on the actual processing of the data and the other metrics that I just referred to. Moving to the next slide, slide 11. So one of the things I think we currently see a lot, especially out on websites or in the context of contracts, is that services are made conditional on the provision of consent. I think a great example is the cookie wall, and especially in European context, you may have encountered that. Where you try to access a website, you get this pop-up saying, well, we use cookies on this website. And do you accept cookies? And then if you don't accept the cookies, then you are not able to enter the website. So there you see that a service is made conditional on the provision of consent. And the GDPR introduces a new obligation or phenomenon in that context and questions the validity of consent if it is made conditional, if it is made as a condition for the procurement of the services. So it's not by definition not considered valid, but as the GDPR phrases it, utmost account shall be taken of the fact. And the way that we read this is that it will there will be a matter of questionability on the validity, whether it has been freely given or whether indeed someone clicked just to accept because he or she wanted to enter the website. And that's something I think that will be quite interesting to monitor and see how that plays out, because there's going to be a lot of instances where this validity in this context may potentially be questioned. I already referred to the cookie walls, but what if analytics or advertising or in the context of apps? I think the examples we encounter are a lot where consent is requested, and if not provided, that may ultimately lead to a lower lessening of the services or no provision of the services at all. So that's one I think also to mind here in this context. Moving on to slide 12. So other things to say about consent. We already knew, that's already the case under the directive, that consent needs to be informed consent. So there is a duty to inform about the purposes for which personal data will be collected and used, to inform about the data controller, etc. One of the elements that has been added to that is an explicit information about the right to withdraw consent. And this, again, goes towards the requirement on the validity of consent, that it needs to be freely given, and that entails that individuals must also be able to withdraw consent, after which the processing of the personal information should cease. And that piece of information now needs to be given prior to the collection of consent. And that's going to be, I think, something that will be maybe somewhat of a challenge. I mean, ordinarily, you would put that information in a privacy notice, but the way that we read this, this could also entail that it's actually proactively given in the context of, for instance, a checkbox or otherwise where consent is being requested. And then another point I think is notable, and this goes towards the point that Karen also made earlier, towards the granularity of consent, is that it needs to be distinguishable in appearance if it is made in the context of other written declarations. I think this goes towards terms and conditions, where you sometimes see that terms and conditions will say, by using the services, you will consent to the processing of your personal data. And it's not, per definition, considered invalid, but this requirement says that it needs to be distinguishable. So a different font, a separate heading, a frame, by and large, you should not bury it in terms and conditions, but make it clearly visible to the user that consent is indeed something that the company is relying on. And with that, Karen, you want to talk about legitimate interest?
Yes, thank you. Slide 14. Then Alex and I talked about the increased obligations for valid consent, and that it's more difficult to do it, and you have to be more granular, and all these new information requirements. But then on the other hand, that's kind of balanced by a quite broader interpretation or language on legitimate interest. And legitimate interest may allow you to collect, to process, to share data without the need to get this more difficult consent. And legitimate interest is really very contextual. It's fact-based, and you need to look at the situation, and then you need to look whether there's an arguable legitimate interest to doing what you want to do, and whether there's some overriding privacy interest of the individuals that would prevent that use of data or sharing of data. So it's a balancing of different interests. And what is helpful in the regulation is that in the past there's been a lot of difference in the interpretation between the different data protection authorities, and what the ICO in the UK considered legitimate and allowed was quite different from what you found in Spanish statute, in Spanish interpretation. And now the regulation kind of introduces and suggests situations where there is a legitimate interest, and this would apply across Europe. So there's recital 38 suggests that where a company collects and uses data for fraud prevention purposes, and that use of data is necessary for that purpose, then you have legitimate interest, and if you then adequately protect the privacy interests of the individuals, then you can do that without having to go back and get all these consents. And another possibility under the regulation now is that it's recognized that companies have a legitimate interest in marketing. They may have that, for example, for first-party direct marketing, so collect information and use that for postal mail and things like that. The difficulty with this particular situation is that the regulation would not override any additional requirements for direct marketing. So you may still need to get consent for email marketing and things like that. But when you talk about general use for marketing, for market research, that may be allowed without consent based on that broader interpretation of legitimate interest. Another helpful addition under the regulation is that use of data for network and information security is recognized to be legitimate and no need for consent, as well as internal transfers of HR and client data. And I think that's ultimately incredibly helpful for larger organizations that need to share employee data, that need to share client data, customer data between different affiliates. Under the regulation, you can do that without consent if that sharing is part of your normal internal administration. But what's also covered now under the regulation, under this balance of interest exception, is you can use information, personal data that's appropriate based on the relationship with the individual, that may, for example, cover the use of contact details. So that's quite useful as well. So I think you have now many situations that are recognized under the regulation that you may use the information based on legitimate interest without having to go back and ask for consent. Then moving to slide 14. There's also a new possibility under the regulation to use data for further purposes, sort of secondary use. And you still have the general purpose limitation principle under European law, so that you are only allowed to collect and use data for specified, for explicit and legitimate purposes. And what's new is that you can use information unless it's incompatible with its additional purposes without really having an additional legal justification. So you don't need consent, you don't need legitimate interest, you don't need another legal basis, provided that further use is compatible with the initial use, and that's quite a change for European law purposes. Then when we talk about what is this compatible further use, and we're moving to slide 15 for that. Basically, what you need to look at is this further use related to the initial use? Is there some dangerous or potential harmful consequences for the individual? What are the data? Probably it's less likely that further use is accepted for when we talk about health data than when we talk about contact information or email contact information. So I think that certainly plays a role. What type of data we're talking about? What's the context? And I think that further use could probably quite helpful for use of big data. I think it's going to be interesting to see how this provision is applied in practice. But I think there could be a good possibility to use data that you initially collected for some further use that's related, that's not incompatible. What you cannot do is to use data for further use where you base the initial collection on consent. So that the initial collection is based on consent, you have to reconsent, and you need to go back to the individual, inform about this further use, and then get consent for that further use. And then the other exception is that you collected the information based on a statutory requirement. Then you cannot apply this thought here as well, and you have to go back and see whether you can whether you have a legal basis to use it further. So you can't rely in these two situations that you base the initial collection on consent, or where the initial collection is triggered by statutory requirement. That's not going to work. Then let's move to a new chapter in the regulation, individual rights.
Yeah, thanks, Karin. And maybe actually one more thing to say about further use, which is the way that this has now been codified and the criteria that companies need to mind. They strongly, they're based on the working party opinion on compatible use, I think. But they also strongly resemble the test that needs to be carried out under the legitimate interest test. And I think it's important to note, because later down in the presentation, we'll get to privacy impact assessments. And there we again see that test being introduced. So to us, that is an indication that the balancing of interest test is one that's not necessarily confined to the legitimate interest ground, as previously could be argued, but under the GDPR is something that I think will go away. So indeed, moving to individual rights, moving on to slide 17. I think this is an area where we see that the rights of individuals, where the scope of the regulation has definitely been expanded. And I think there's much to say about this. We've put a number of these topics and rights on one slide. I think we could have easily filled a number of slides with them. But we just wanted to point your direction to some of the requirements that I think are most notable. And that's to start with the level of information that companies need to give by way of a privacy notice or privacy statement to data subjects, to individuals. As I indicated earlier, we already had the obligation under the directive that such information includes the purpose of processing of data, the identity of the data controller, etc. But now we see that under the GDPR, the list has been expanded of what needs to be included. Not only do companies have to include the legal basis based on which the data is collected, which will be particularly interesting if the basis is something else than consent, right? Legitimate interest or execution of agreement, those kinds of things. Another interesting point, I think, that I've to date not seen any company include in, or at least very few in privacy statements, is retention periods. How long will the data be retained? And the guideline there is that data needs to be retained for as long as it's needed for the purpose for which it is collected. By and large, that's something that you would put in your privacy statement. But I think the real question is whether regulators are going to ask for even further detail on retention periods and require companies to include, specific time, specific periods. So 2 years after the data was collected, or 5 years, or whatever it is. It is an explicit requirement under the GDPR that be included. The same for information on transfers, whether or not there's profiling. The right to lodge complaints with DPAs, making that explicit so that individuals know where they have an act of recourse if they have a complaint. And also the source of data were not collected directly from individuals. That's, I think, something, that's an obligation that's currently also in the directive in many national laws, where you have to document the source of the data if you cannot, if it wasn't collected from the individual directly. But now that's also something that needs to go explicitly in the privacy statement. So that's going to be an expansion, I think, of privacy statements as we know them, and a further level of granularity here towards that.
And some of it may be rather tricky, because when you look at, for example, the new obligation to kind of detail the interest and the grounds why you believe that you have a legitimate interest in collecting certain information. I think there's quite often a lot of thought why you believe that something is legitimate, but it's not necessarily something that is easy to explain to individuals, and that you can easily document. And you may not want to disclose all of that, but that's again a new requirement in terms of notice to individuals under the regulation.
Yeah. Another interesting point is on access rights. The right of obtaining access is not new. We already know that, but it is definitely fortified under the GDPR. We see that access must in principle be given free of charge, although for further copies a reasonable fee may be requested based on administrative cost. I think it's interesting that the wording specifically refers to further copies. So to me, that indicates that a first request should in fact be free of charge, and that administrative fees only pertain to further copies. I think that's something, as compared to many national laws currently, is not the case. A lot of laws currently provide already that data controllers can charge reasonable administrative fees even for the first copy to be requested. Also, in the context of access rights, there's a host of information that may need to be provided to the individual, especially in the context of profiling. Much of the information that you would expect also to go in the privacy notice based on the transparency requirement, but that's also something that may need to go into the response to access requests. So what's the logic involved in automatic data processing? And what may be consequences of such processing. It's interesting because the considerations mention that the company should use all reasonable measures to verify the identity of a data subject, of an individual who requests access, but that does not go so far as that there is a requirement to retain or process additional information for the purpose of being able to identify. So if you are a website and you use cookies or you collect IP addresses, as I earlier alluded to in the context of online identifiers, there's no requirement to collect additional information so as to be able to respond to access requests if that should be lodged. So if I were to ask a website, can you give the information you have, without providing the IP address or cookie or other identifier, the website would simply respond and say, well, I don't know, I cannot identify what is your data. And in that context, I'm not able to provide you with an overview of the requested information. But still, I think that's the access right is something we don't see it that often, I think, or at least I know that some companies encounter more access rights than others, or exercise of access rights than others. But again, it is something fortified under the GDPR, so it'd be interesting to see how that plays out and whether indeed individuals en masse will now start using the right vis-a-vis companies.
Yeah, and I think traditionally, the access rights were a lot used in the UK and in Ireland, and much less so in continental Europe. And given that there's now this obligation to inform individuals expressly about access rights and give a lot of detail on that, there's a chance that individuals in Europe will make use of that right to a much larger extent, and then that would mean that companies would need to deal and address these increased flow of requests.
Yeah. Another individual right that is codified under the GDPR is the right to erasure, or the right to be forgotten, I think, as the more catchier phrase is. It's not necessarily new. We already had the European Court of Justice in the Google Spain case indicating that there is such a right to be forgotten. And I think ever since that's something we see pop up also outside of the European Union. And we know that Russia, we know that Turkey are all either implementing or applying a right to be forgotten. It basically, also as a concept, I think it's not new. The directive already provides a right to object to individuals. So if there are compelling grounds for the individual, for the data subject, to object to the processing, that could be a reason to request seizure of processing. But by and large, I think the right to be forgotten goes one step further than that. The threshold for exercising the right is definitely lower than under the directive, and it actually also entails the erasure of information, of data, within a time period without undue delay. So I think it will have a more a higher impact on companies getting these kinds of requests. What's interesting, I think, on the right to be forgotten is I think the right is most intuitive in the context of search engines, as it was applied also by the European Court of Justice. Right, that's information, that's public information, and we see that individuals, data subjects, often have a concern about information that's still retrievable. So that's where we understand this right primarily to be lodged. However, the language in the GDPR does not limit it at all to any specific sector or type of processing or type of company. So the right can be lodged against any company. And it means that if an individual withdraws consent or on grounds relating to a particular situation, so if the data are no longer necessary or if they have been processed unlawfully in the mind of the data subject, then a request for erasure can be lodged. It's not an absolute right in the way that there's exemptions in the area of freedom of expression, scientific and historical purposes, legal obligations. I think most notably, if you as a company have a legal obligation to retain the data, then obviously that's one that needs to be complied with. Although I do note that that's a European legal obligation and not necessarily a foreign legal obligation. For instance, if you're headquartered in the US or in Japan or other regions of the world, those kinds of legal obligations under the GDPR will not actually trump the right to erasure, or at least not necessarily. But it's interesting. We'll again here see how this plays out with companies and whether individuals will indeed make use of this additional right, which notably under the directive was not the case. So one of our points of takeaway in this area is that we advise companies to review and complete their notices, especially where they have additional obligations to inform individuals on the processing of their personal data, and to implement processes to be able to cater and address for the exercise of either existing rights get fortified or additional rights. I think the GDPR does introduce a more stringent regime with regards to timelines for response. So that's one that you may want to review and think about as you go over your internal processes in this area. Moving on to the next slide, number 18. Data portability, it's another right that didn't fit, I think, on the previous slide anymore, so we do have one more slide on that. It's an extension of the access rights. It provides that individuals are permitted to request a copy of their personal data in a commonly used electronic and structured format. And our expectation is that this is a right that will probably be most effectuated in the relationship between a data subject, an individual, and a service provider to that individual. So a phone company or an internet service provider, where it actually makes sense that data will be that the individual would want one service provider, one phone company, to transfer certain information to the other phone company in a commonly used format. Other than that, we're not really sure how this will play out. But again, this is a right. We'll see how this will be exercised in practice going forward. Do note that this too is not a right that is unlimited. It applies when data are obtained via consent or contract. So if you rely on the legitimate interest basis for collecting information, then this requirement would not apply. It's only if it's consent and contract. And it must obviously not adversely affect rights and freedoms of others. So I think with that, I'll hand it over to Karen to talk about transfers.
Thank you. And in response to the question, are existing transfer mechanisms valid? I think it's a clear yes. There's been a lot of debate during the process, and there was suggestions to have kind of a timeout period for existing mechanisms for standard contractual clauses. And the ultimate decision was no, that's not going to work. Let's stick to what we have, basically, and you still have a system that transfers outside of Europe are prohibited unless you have adequate findings, unless you have adequate safeguards, unless you're subject to a derogation. So you have these three possibilities to move data out of Europe. And do not forget these transfer restrictions apply in addition to local requirements, so that in a situation where you may be able to share customer data or HR data with affiliates in Europe, you may do so as well with affiliates in the US, but only if you have this additional layer in place, the transfer restrictions. So you have a question on whether you have a legal basis, and that may well be for inter-affiliate sharing, may be sharing with affiliates, and that's considered legitimate. And then in addition, you may need to implement an adequacy mechanism because you do that outside of Europe. And then for adequacy mechanism, I think the first possibility is you're always allowed to share data with a recipient or recipient country that is considered adequate. There was, again, a lot of discussion who should have the last word on what is considered adequate. Decision at the end was that would be the Commission that would, in the first instance, determine whether a country, whether a sector, whether a certain territory is providing adequate protection. There's now a lot of more detail in the regulation what criteria should be included here, including foreign governmental access, certain line with the thinking of the European Court of Justice on Schrems. And if you have that adequacy finding, then you don't need further authorization. And Alex will talk later about Safe Harbor 2 or the Privacy Shield, because that may be a adequacy finding. The second possibility to get data out of Europe and and that remains unchanged, is that you can put in place adequate safeguards. So you still have the standard contractor clauses. You have the standard contractor clauses for data processes from 2010, and then you have the two different sets for standard contractor clauses for sharing with data controllers. So that remains unchanged. They continue to be valid at this point. What is new and but essentially a codification of existing guidance from the Working Party 29 and from authorities is that you have BCRs officially recognized in the regulation. You have a more streamlined approval process, and you have certain elements that the BCRs need to address. So it's basically a codification of existing guidance. And then you can also, and that's kind of the third pillar, you can also share data with non-European countries, non-European recipients. You're subject to an exception, and you have the usual exceptions, such as where you have consent. That needs to be explicit now, that you can share data. We have a contractual necessity where you need the data outside of Europe for legal defense and things like that. But what is new is that you also can share data with a non-European recipient, is where you have compelling legitimate interest. And there's been a lot of debate on using legitimate interest as a standalone basis for sharing with non-European recipients. But in the end, it's a very narrow basis, so it has to be a compelling interest as opposed to just a legitimate interest. It can't cover repetitive transfers. It only can cover a very limited number of individuals. And that's probably the greatest hurdle, is that when you want to rely on that exception, you have to inform the local data protection authority. So that may take more or less the form of an authorization. So in practice, unfortunately, that's not going to help an awful lot to share data.
We're on slide 21, by the way.
And then continuing on slide 21 is, I think there's been all this debate on sharing and disclosures to foreign authorities. And there's been at some point a explicit authorization requirement. I think the compromise that was found and wasn't even supported by all the authorities was that basically the regulation refers back to existing agreements on legal assistance. But that's not really a solution, and companies are kind of left between a rock and a hard place when they get access requests for information from non-European authorities in relation to European data. So I think it's continuing to be an issue, and the regulation doesn't really resolve that. And let's move on.
And just to add to that, so the UK actually opted out of that restriction. And just by way of background, the UK is one of those countries that has the ability in general to opt out of certain European measures. They negotiated and agreed that many years ago when they became part of the EU. And they have used that power to opt out of this Article 43A, which means that they are in the UK, companies are not limited to share data with foreign authorities and courts only on the basis of a mutual legal assistance treaty. So there's a broader possibility in the UK to transfer data to foreign authorities and courts.
Yeah, and I think that's very much in line with the existing arrangements that the UK accepted e-discovery to a much greater extent than most continental European countries, and Gleicio took a much more pragmatic approach towards access requests. Then let's talk about pragmatism, privacy shield.
Yeah, so we're on slide 22 now. We although the privacy shield is not a topic of the GDPR as such, we couldn't leave this opportunity to say a few words about this. I think in the context of data transfers. We all know, I think, by now that safe harbor has been invalidated by the European Court of Justice. We know that at a political level, the European Union and the U.S. have been working diligently on putting in place something new. We had a number of European DPAs issue statements in the fall of last year and early this year saying that if a resolution would not be achieved, would be found that companies would not be able to transfer information to the U.S. anymore. So those are pretty bold statements and potentially have a huge effect on transatlantic trade as such. Where we are now is that a draft adequacy decision from the European Commission has been published. We have further specifics about the Privacy Shield program. It's not formalized and in effect yet. In order to do so, there's a number of institutions on the European side, a number of institutions that are looking at it currently, including the Article 29 Working Party, so the collection of data protection authorities from the various European member states. And once they have issued their opinion and their viewpoints on the Privacy Shield, then it can be formalized and adopted thereafter. The Working Party is expected to convene early April, so by mid-April we're all hopeful for a positive outcome also by the Article 29 Working Party, after which the Privacy Shield can probably be adopted. So going to the next slide, number 23, just to talk a little bit about the Shield itself. As far as we're concerned, it's not a Safe Harbor 2.0 for the reason that there are a number of minor and a number of major differences with Safe Harbor that the Privacy Shield introduces, and that make a big difference, I think, for companies that are subscribing to the Shield. So one of the aspects, one of the things that the European Court of Justice found was that there was not sufficient judicial redress for data subjects, European data subjects in the U.S., and that's notably something where a lot of attention has been put into with regards to the Privacy Shield. I think there's now 6 avenues of judicial redress, ranging from lodging a complaint with the company itself, to submitting to arbitration, to lodging complaints with European data protection authorities, to lodging a complaint with a ombudsman person, which I think is an institution that's very common under European law, but quite uncommon or even foreign under U.S. In the U.S. context. So there has been a heightening of the judicial scrutiny and avenues that can be walked by an individual for sure to start with, and then also in the context of oversight and liability, I think companies that are submitting to the Privacy Shield are facing increased scrutiny in the U.S. with regards to enforcement and oversight, much more so than under the Safe Harbor program. And in addition to that, there's a number of substantive changes as well, including the transfer with third parties, onward transfer both to agents as well as third-party controllers. There are additional requirements there and liability provisions for U.S. companies having certified to the Privacy Shield. What's interesting, I think, in addition to note, is a question arose whether or not the position of the European DPAs would be that transfers to the U.S. would not be possible, also not on the basis of alternative mechanisms, such as standard contractual clauses or binding corporate rules. As we read the Shield, we understand that the judicial redress is awarded to all European data, so that would indicate that the alternative mechanisms also would benefit from the redress avenues, which hopefully indeed will cause European DPAs to still permit those mechanisms to be put in place. We expect that is indeed the case. It'll be interesting to see to what extent U.S. companies will indeed sign up to the Shield, considering that there are so many additional requirements and obligations being put as opposed to Safe Harbor. whether the same level of adoption will be achieved. And then finally, one more thing to add is I think it will be equally interesting to see what the Europeans are going to do with regards to judicial redress and government access to data. That's not going to be limited to, that's not something unique to U.S. powers. So whether or not similar issues will be raised with regards to other nations and governments is something that I think is a realistic option. And we'll see after the Shield has been finalized and has been implemented what the position of the DPAs will be in that regard. With that, we turn to service providers and the requirements. Karin? Karin, maybe you're on mute still because I don't think that we can hear you. I think we may have lost Karin. So in the meantime, I'll take it further. The service providers as being processors are now directly subject to the obligations of the regulation. And previously, this was an obligation only on data controllers, and indirect obligations were put in contracts with service providers. But this is something that has now changed. Oh. Processors are directly subject. Karin, do we have you back?
Yeah, can you hear me now?
I can.
Yeah? Oh, super. Sorry. No,
Great to have you back. You want to continue?
Yeah, I'm happy to. I could hear, so I just continue on that point. I think on service providers, previously, before the regulation in most countries, obligations on service providers were either minimal or not existent in most countries. Now the regulation imposes a range of new requirements, and coupled with the new pretty substantial penalties, but it's quite a shift now. And one of the first obligations and first potential liabilities for service providers is that service providers may only process the data on instructions from the customer, from the controller. They need to establish documentation. I think, and we will talk about that later. So it's basically internal records, setting for what kind of data, for what purposes, and they need to maintain that. So it's quite a lot of additional red tape on that. Then they need to coordinate and cooperate with the data protection authorities. They need to implement security. I think we had that in many countries, but security is now a different level and more detail. And then you also have to, the service providers also have a new obligation to appoint a data protection officer. I think in the final version that was agreed, the obligation to appoint a data protection officer is now more limited. It's basically only service providers whose core activity is to process a large scale of sensitive data or to regular monitor. So it seems more limited than initially thought of. But I think, for example, many online tracking services, online marketing services, may now need to appoint a data protection officer, because I think there's surely an argument that they regularly monitor individuals. And another quite a change is that service providers are now, for the first time, directly obliged to put in place transfer mechanism to third parties. So they have to put in place contracts and really think about this for the first time. So it's not just the customer obligation, but it's the service provider obligation. And then also the service provider have to notify the customers if there's a data breach. So it's still different from many states in the U.S. It's not the service provider that has to notify the regulators or the individuals about the data breach, but the service provider has to tell the customer, and then the customer has the obligation to go to and inform the authorities and the individuals as appropriate. So I think there's a whole range of new requirements for service providers. And then let's move to slide 26. It's not just service providers that are affected here, but it's also the customers, because there's now a fairly explicit list of issues that the customer has to address in the agreement with the service provider. And that provision was actually modeled after the German Data Protection Act, where you already had this 10 points that the customer had to include in a service provider agreement. So he had to document the instruction and how the service provider had to use the data. You had to include confidentiality obligations on the service provider. You have to restrict the service provider subcontracting. Good news is that a blanket upfront consent is sufficient. So it's not required to really get consent case by case. That would definitely not be in line with market practice. So some upfront consent is possible, but if you select that solution, you still have to include an obligation that the processor notifies when they use a different sub-processor, and then the customer needs to retain a right to object to the use of that additional subcontractor. So that's probably going to be tricky. Another obligation that the service provider agreement now needs to address is that the service provider has to delete or return all the data after the service is rendered. And there's are specific duties of care in selecting sub-process. So it's quite a comprehensive list of things that service provider agreements now need to address. And it's probably a good idea to start reviewing existing arrangements with service providers and switching to the new model, switching to the new requirements, so that over time, and you have 2 years that the new agreements are in place, and so that you don't have to basically put all the service providers on new contracts, and then the regulation is entering into effect. So I think use the interim period to address these new requirements here. And then specifically with respect to cloud services, based on slide 27. And as we said, I think for cloud service, it's quite a change, because where there are processors, you have these new obligations, you have increased liabilities. And then in many instances, or in some instances, it depends on where the services are going, the cloud provider may not be considered a data processor, but may be considered a data controller. And then you have a much broader scope, and a lot of these services would then be directly subject to the regulation.
Yeah, and on transfers, I think what's interesting to note in the context is BCR for processors, BCRP. We're already seeing a lot of cloud suppliers and other vendors choosing the avenue of BCR for processors to facilitate the cross-border transfer of information, of data from a customer in the EU to a service provider outside. That will be explicitly recognized, so that's a good thing. As indicated earlier, the privacy shield may be important for U.S. cloud providers. We'll have to see to what extent that will be adopted. And I think the part on consent, I think, Karin, you already touched upon with regards to the use of sub-processors. Maybe one more thing to note is on the privacy impact assessment. We'll get to the privacy impact assessment hopefully in a few minutes, but just to note that where you have an obligation to carry out a PIA, you may need the cooperation of your service provider for providing actually the input to the PIA. And that's something, that's not unique to cloud service providers, but especially where the underlying data triggers the requirement of a PIA. that's something that also in the context of cloud may come into effect. Moving on to slide 29. And we're mindful of time, folks. We have a couple of more slides to go. Hopefully we'll get to one or two more questions at the end of this session. So with regards to the lead DPA, or also referred to as the one-stop shop, I mean, just to note that I think this was originally presented as an alleviation, as something that would make life easier to companies. As originally proposed, companies would then also only have to deal with one DPA for all of their European operations, being the DPA of their main establishment. Now, the way that this has turned out in the final version is not quite the same. There is still such a thing as a lead DPA, and it is indeed the DPA of the main establishment, or where important decisions are made as to data processing. But it does not affect the powers of the national DPAs in all respects. It's rather the way that the one-stop shop or the coordination has been set up is that it is, in fact, a matter of coordination, cooperation between DPAs. So national DPAs still have the power to investigate, especially with regards to events taking place within their jurisdiction or pertaining to to individuals residing in their jurisdiction. The cooperation entails that they will work with the DPA, with the lead DPA, to funnel inquiries and complaints, etc. But it does not mean that companies will indeed effectively only have to deal with one DPA for all of their European operations. So it's not, unfortunately, it hasn't turned out the way that we'd hoped to, which would have made I think, a big deal. But again, there are some changes in this area. Karin, you want to talk about security breach?
Yeah, just very briefly, given that we don't have that much time left, security breach requirement. I think in a few European countries you already have a local obligation to inform regulators, to inform individuals about security breaches. But in most countries that's fairly limited. In some countries even not mandatory, but it's a recommendation from the regulators. The regulation changes that. You have a overall rather broad requirement to notify the data protection authorities, and in some instances also the individuals about data breaches. And the final deadline that was agreed upon is 72 hours. And that may appear long, but I think given that you often have a chain of events and not all the information is available and you have different time zones, 70 hours in the end is an incredibly short time. And in order to really meet that, you will have to be prepared and have a data breach response plan ready in case there's an event, and there will be. There's an exception from the obligation to notify the regulator, and that is if the breach is unlikely to result in risks for the individual. So that's quite helpful because, for example, there you have encrypted laptops and the laptop gets lost, then I think there's a good argument that there's no risk or likely risk for individuals, or where you have good password and other protections. So I think it really pays off to implement good security standards and then hopefully qualify for that exception from the breach notification requirement. Notification to individuals is limited. You only have to notify if the breach is likely to result in high risk. So it's more limited. And then when you look at what the notification needs to include, and that's on slide 32, there's quite a lot of detail. So I think you better be prepared and have some language ready. The notification needs to include the contact details of the organization, of the data protection officer where available, likely consequences of the breach, and then all the measures and the things that the organization did in order to address the breach, and that's rather tricky how you spell that out and how you limit risk at that point. Then the notification to the data protection regulator also that needs to include the nature of the breach and categories of data. So I think the brief message is that the notification to the individual and the notification of the regulator are somewhat different. There's a common set of information, but I think there's additional details. And let's move to. I think we already discussed the data protection officer to some extent, Alex.
Yeah, I think we did. Maybe one comment to make on that. The threshold for implementing a data protection officer has been under much debate. The outcome is that it's not attached to a number of individuals or employees that you have, but whether the processing of data warrants a data protection officer. So I think it doesn't mean, in our expectation, it doesn't mean that all companies are required to have one. Of course, if you have a DPO, it may actually help you in your privacy governance compliance. So thinking about a DPO outside of the context of the GDPR may be something worth to consider. Otherwise than that, if you are subject to this requirement, there's a host of qualifications and obligations on the DPO and on the company to make this work.
Yeah, and then one of the obligations or tasks of a data protection officer, when you have one, and that's on slide 35, is to establish documentation, internal documentation. That's really kind of an internal record of what data you have, who has access, where is the information, really very much about under the directive in many countries you had to tell the regulator. Now that is kept internally and needs to be maintained and updated as appropriate. And this obligation really applies to both the controllers and the data processors. So it's a new requirement, and it can be rather detailed. So it depends a little on how this is interpreted and what the real life request from the regulators will be. I think you already have a similar requirement in Germany, but when you look at the enforcement in the different federal states in Germany, it's quite different what you have to have in terms of documentation in Schleswig-Holstein as opposed to Baden-Württemberg in the south where you have some minimal requirement and you can get away with rather general information. So it depends a little on how this plays out and how the regulators interpret this obligation. There is a exception for small, medium enterprises. So if you have a small, medium enterprise with less than 250 employees and you don't process sensitive data, it's all very occasional, then you don't have to have that documentation. So these mom and pop shops are outside, but all the other organizations are probably included because this 250 employee threshold applies across the enterprise. So it's not by legal entity or by office, but it's across the enterprise. And a lot of organizations will be above the threshold and have now to establish this written documentation and maintain that and update it. And Alex, do you want to talk about the privacy impact assessment? It's slide 36.
Yeah. So the privacy impact assessment, the DPIA, that's something that's newly introduced under the GDPR. We don't have it currently. It is the threshold is when there is a high risk processing that has a high risk with regards to the data of individuals. The regulation mentions some examples of when a processing is considered high risk. So that's if there is a CCTV or when you engage in profiling, when you process sensitive personal data. New technologies can make processing high risk. But I think it's important to note that despite these examples, the GDPR sets an open norm. So other types of processing may still qualify as high risk and therefore warranting a privacy impact assessment to be carried out. In fact, the GDPR explicitly mentions that national data protection authorities will draw up lists of processing that require a PIA, and they may draw up lists that do not require a PIA. So this, I think, is an area where we'll see further guidance or even further requirements come out as to when a PIA is required. And there are some exceptions as to when a PIA is not required. I think if we move to slide 37, a question that we often get, and what many companies may be thinking about, is to what extent the documentation requirement can or cannot be, or should not be, combined with the privacy impact assessment requirement. Stemming from the fact that the information that needs to be put into a PIA to great extent overlaps with the information that needs to be put in the documentation, under the documentation requirement. And while there are indeed valid reasons for combining the various requirements, there are, I think, a couple of points to take into account in this area. First is that the threshold for carrying out PIAs is higher than for the documentation requirement.